What's up, everybody, and welcome back to another exhilarating episode of Lockdown 23-1. I've had many people tag me on TikTok and Instagram to do a review on this video. Another glorious sentencing day is upon us, ladies and gentlemen. If you're new to this channel, we talk about all things prison and crime related, including people getting sentenced to prison. What exactly goes on during these trials? What are these people thinking about? Anything you can think of when it comes to the justice system, ladies and gentlemen, we talk about, and we try to make it fun. Who don't need a little more fun in their life? But hit that like, subscribe, notification bell if this is the kind of content that you're into, ladies and gentlemen. Cameron Herrin was heading to the gym on the morning of May 23rd, 2018. Witnesses later told investigators that Herrin and his friend John appeared to be racing on Tampa's Bayshore Boulevard. Police said a woman was pushing her daughter in a stroller when Herrin's car hit him. Prosecutors presented evidence that the Mustang topped 100 miles per hour, moments before the crash, rapidly decelerating. This young man's about to be sentenced today, right before your eyes, for street racing that took two people's lives. Of course, this guy's probably facing the worst kind of situation with this one. A mother and her daughter in a damn stroller. What do you think's gonna happen to this young man today? 5 years, 10 years, 15, 20. All right, let's do this, ladies and gentlemen. I do apologize to the headphone users out there. They don't use the best audio recording equipment in these court cases, I've noticed, because a lot of them you can only hear out the left or the right headphone. So I don't know what they're using, but it ain't that good. Water bottles got me thirsty.
That's right. It took me a little bit longer than anticipated, but that was a lot of information to consider.
It's okay, Your Honor. That's a beautiful court.
Let me just start by saying that as multiple people have observed.
Look, that thing has freaking marble countertop, nice wood finish, and of course the water dispenser right there with the chrome and black trim. Every time I see them pour water out of them, I get really thirsty.
This is a particularly difficult case because there's really nothing that the court can do that's capable of fixing the harm that has been caused to the victims in this case.
See, even the judge knows that this is just a horrible turn of events. This kid should not be in this courtroom. This kid should be out enjoying his life, going to college, wanted to do a little street race with his buddies and ruined his life. And the judge knows. He knows this shit is a sad situation.
So that being said, I've got to start with the law. I'm bound by the law, and the law gives me a guideline for how to analyze an appropriate sentence in this case. So I want to start with the Camacho
good old
case.
Guidelines.
It's really the first thing I need to address is whether or not the court's going to depart from the minimum in this case, which is 222 months, or approximately 18 and a half years in the Florida State Prison as a minimum.
He's saying he doesn't know if they're going to depart from that, meaning go above and beyond. I mean, considering the circumstances, a woman was pushing her daughter in a stroller, I would say that's plenty enough to go above and beyond. But like we all know, it wasn't intended. It was just bad timing. They have these guidelines put in place to help the judge sentence people, to keep more of a consistency when it comes down to sentencing across the board. They use these guidelines. But like I just said, certain situations they can go above them or below.
Gibbons pointed out and argued, lays out really a three-factor test. Is there a valid legal basis for departure? Is there competent substantial evidence that the facts support an application? Or so do the facts apply to the departure basis that is being asserted? To both of those questions, I answer those yes. There is a valid legal basis for departure, and there is competent substantial evidence that would support a departure.
A departure from, let me remind you, the minimal sentencing. He agrees that this is a perfect situation to break away from that minimal sentencing. So me, now, right now, knowing everything that I know about the court process, if I was in that young man's shoes in the courtroom right now and heard that judge say that, I would ask for a bucket of water because I know the smoke boots are coming.
And really, I'd find that as to all of the departure bases argued, with the exception of the disparity argument. I'll just comment on that one for a moment. The defendant has argued that an available basis for departure is the disparity between the guidelines and the sentence that Mr. Barano got. I don't agree with that. I agree that disparity could potentially be an available legal basis for departure. But in this case, I don't think it applies because I do think that there are important substantive differences between the facts as applied to Mr. Barano and the facts as applied to Mr. Herrin. You know, when evaluating an appropriate sentence, I will start with Florida Statute 921.002. It was pointed out several times the primary purpose of the criminal punishment code in Florida is to punish. And I've got to take into account the severity of the primary offense and the circumstances surrounding the primary offense. When I take into account circumstances and severity.
I think this judge is nervous because the cameras are on him or something. I don't know. He needs to let it flow a little more, man. Relax, bro. You're the judge.
A lot of what I'm taking into account really when I sentence is intent and harm. And in this case, there wasn't any evidence, and nor does the court believe that there was any specific intent to do harm, in this case to the victims. But there was intent to drive at an egregious speed, 102 miles an hour, regardless of the consequences and regardless of who that ended up harming. And then the second part of that, the second component, is the harm caused. And in this case, it's just impossible to have greater harm than the harm that occurred in this case. I did consider, I also want to make a record, I did consider sentencing Mr. Herrin as a youthful offender, but for the same reasons that I'm discussing, I didn't think sentencing him as a youthful offender was appropriate. I agree that youthful offender was something that the court could have done. I did consider it. I carefully considered it. But the court just found that due to the serious nature of these offenses, the extreme nature of the conduct, and again, the level of harm, that a youthful offender sentence was not appropriate.
If he got youthful offender, would have been way less than as an adult. He would have gotten way more of a slap on the wrist. So the guy must be 16, 17, somewhere very close to adult or just turned adult. And the judge decided not to charge him as a juvenile, but as an adult. And they usually do that if the crime is serious. You know, you got these judges who have justice to uphold for the whole community, you know? So, I mean, if I was a judge and this is a huge thing within the community, and not to mention, you know, just the seriousness of the whole situation, it's definitely enough to charge this guy as an adult.
The guidelines call for a sentence of 18, essentially 18 and a half years at a minimum and 30 years as a maximum. And the court doesn't find that either the minimum or the maximum is appropriate in this case. I've said it several times, the serious nature of the offense, egregious nature of the conduct, and mostly the harm that's been caused prevent me from putting this as a bottom of the guidelines minimum case. But the departure bases argued by the defendant did provide some reason not to put it at the top of the maximum. And specifically, the court did take into account that the defendant's 18, certainly responsible for his actions, and he's being held accountable for his actions. But the age of 18, the court finds, is a mitigating factor and shouldn't put this at a maximum. Also, the complete lack of prior criminal history is something that the court considered.
So he was 18 when the whole thing took place. Of course, he's an adult. He's an adult. When you're 18, shit changes. Remember that. It really, really does. But I'm sure he has a really good attorney, and the attorney was pushing for the youthful offender. That's why the judge brought it up, and the judge could have went with it. But he decided not to, and he's also decided not to go with the minimal. He said, I do not believe the minimal nor the maximum is suitable for this case. But his age and not having no kind of criminal record saved him from getting a full 30.
Prior criminal history is something that the court considered as preventing this from being at the top. So having said all that, the court is going really toward the middle between the minimum under the guidelines and the maximum punishment permitted under Florida state law. So on count one,
Dude's about to get smoked.
vehicular homicide, the court's going to adjudicate the defendant guilty, sentence him to 9 years in the Florida State Prison. On count two, same charge, court will adjudicate the defendant guilty, sentence him to 15 years Florida State Prison, and that'll run consecutive to count one.
Dang.
For a total 24 years Florida State Prison.
Tunnel vision.
Count three is a misdemeanor, unlawful racing on a highway. So the court will adjudicate
ain't hearing
the defendant
nothing
guilty,
else
sentence him to
after
time
that.
served.
He's calculating the first
Give
two
credit for time
sentences.
served, I believe, 2 days. Court will impose mandatory court costs. Mr. Herrin, you have given up the right to appeal the determination of your guilt or innocence. You do have 30 days to appeal the sentence of the court. And I'll direct the bailiffs to take Mr. Herrin into custody.
You see how his eyes got bigger after, what do you say, 15 piece? You got 9 and then 15, 24 years? You got credited for, 2 days? You got a little head start, didn't you, buddy? But you see how big his eyes got when Deuce said 15? It's because these type of cases where the kid is just a kid for the most part. Just got out of high school probably. Ain't got no criminal record. He's probably on his way to college. Might got some scholarships. Situations like this are so inconsistent. You know, the victim's family has a lot to play in these situations as well. I've seen someone get only 4 years for killing someone in a somewhat similar situation like this. But the person who died was his friend, and the victim's family made sure that the judge knew they didn't want his friend to get smoked. So these type of situations are always a toss-up, and as you can see, this guy probably had no idea he was going to get 15 right after the 9 piece. He probably still had a little bit of hope. 9? It's not that bad. 15 followed by the magic word consecutive? Oh no. No, no, no. Now I have 2 things I'd like to point out about this story. 1, street racing is very dangerous. Very dangerous. And number 2, when you turn 18, shit ain't no game. You're a big boy now. And when big boys get in trouble, go to lockdown. 23-1.